When people have disputes or businesses have disputes, what we commonly think of is being sued. Someone will say, oh, I just sued so-and-so, or if you mess with me, I'm going to sue you. When they do that, they're talking about litigation, which is the legal process to resolve disputes through the court system. A judge and a jury, the attorneys go into the courtroom through litigation. It's a series of process. You have filings with the court, you have procedures that must be had, discovery, and it's through stages that last anywhere from a year to several years. It's an ongoing process to resolve a dispute through the courts. Over the past several decades, you've had alternative dispute resolutions developed, mainly arbitration and mediation, which are separate from each other. Arbitration, the parties present their evidence. They still have it's an ongoing process where they may exchange information. Then they present their evidence to a panel of arbitrators, and then the arbitrators render a decision that is binding on the parties. Just like a court or a jury would do in a courtroom, now the arbitrators do it. They still render the decision that's binding on the parties. Because it is a private not through the public courtrooms, and you pay a little heavier fees for the arbitrator, the amount of time is usually less than you would through litigation because it's not through the courts. Think of it, the line's not quite as long to get a case to mediation or to arbitration. Mediation is an isolated event in which you have a mediator, a third-party neutral, that sits with the parties and helps them resolve the dispute through a settlement agreement. Mediation usually takes place in the context of litigation through the court system or through an arbitration, but at the end of the day, it's an isolated event that if the mediation is successful, you have a settlement agreement and the dispute's resolved, or if it's not successful, you continue on to the court or to the arbitrators. Collaborative law process is different in that it's not an isolated event within the context of litigation or arbitration. It is a process to be used instead of litigation or arbitration. And in that process, from the very beginning, you have confidentiality, you have the parties designing their participation agreement, identifying what type of information is going to need to be exchanged, what type of experts we may need to call in to help us, the timing of how long you're going to give the process to work before you resort to litigation if it's not successful. But it's an ongoing process that brings the party together to work toward a settlement. Collaborative law process, sometimes you hear it collaborative law practice, is a new old way to resolve disputes. It was designed originally from a family law lawyer, Stu Webb, in Minnesota, who became frustrated with the legal system, or at least frustrated with the process. I think he realized there's got to be a better way than the adversarial system where the two sides are geared up to wear each other down, beat each other down, tear each other down. And a lot of times that is what traditional litigation does. So he reached out to other lawyers in his community, and they designed this new process, collaborative law process, which there are 4 elements to collaborative law. One is you create a team, the collaborative law team. Each party still has their own attorney, and then there is a collaborative law facilitator, which would be a neutral third party. And then you may also bring in other experts to be part of the team. Who those experts will be depends on the type of case. In the family law context, the collaborative law facilitator, the neutral third party, is usually a mental health worker, mental health therapist. And some of the other third-party experts may be accountants, CPAs, people familiar with finances, because that's discussed in a family law case. In non-family law cases, those third-party neutrals and those experts will be different depending on the type of case. But going back to the core of the collaborative law, you have this team. And one of the essential elements of it is both the attorneys and their clients agree that if it's not resolved in the collaborative law process, that the attorneys won't represent the clients in continued litigation over that matter. The collaborative law process isn't just a practice area for me. It is something that I firmly believe in to be a better way to resolve disputes. And I say this as a litigator who has been in the courtroom. I enjoy being in the courtroom, but I see it is not the best way to resolve disputes. It's often destructive on the parties, and there's a saying, and it's a saying for a reason. At the end of the day, at the end of litigation, there are no winners. Even the winners lose. And they lose because of the amount of time that they had to take away from their lives to focus on the litigation, the cost, their attorney's fees, which are two separate things, and just the stress that they have this ongoing that takes them away from their business or their lives. I'm a commercial litigator. A lot of the disputes that I handle are for businesses as well as individuals. And so I don't want this to come across as, sometimes when people think of collaborative law, they see it as a soft, touchy-feely type thing. It's not like that at all. It is helping businesses, helping individuals focus on their business. You can get sucked into the litigation process, and when you do, it takes away focus from your business. And if you're an individual in a dispute, it takes away focus from your life. And it doesn't have to be that way. I think the best way to understand how this case has motivated me so much and has left such an impression on me and has driven me to be an advocate for collaborative law is to understand a little bit about the case. I represented an elderly couple. The husband was in his 80s, the wife was in her 70s, and they bought a home in South Florida. They were wealthy. It was a beautiful home that was encased in this cast stone that gave the home a regal castle-like look to it. My clients loved that home. The wife actually loved it because of the cast stone. It was the only home that she had ever seen, and it was certainly the only home in the entire neighborhood that had the whole exterior in this cast stone, which kind of became an ironic point because the cast stone, once after they moved into it, it was really the central focus of the case because there were issues with how the cast stone was installed. Underneath the cast stone and led to water intrusion issues into the home, and there were also issues with the roof and other aspects of the home. So in this case, I represented the couple, the husband and wife, 80, 70-year-old couple, in their purchase of this home. The defendants were the seller of the home, his real estate agent, and his real estate agent brokerage firm. The defendants also pointed the finger to non-parties, which they were allowed to do in the system, which allows them to go to the jury and say, these people aren't part of the lawsuit, but we think they're to blame. And they did that to our clients, the buyers, real estate agent, and the real estate agent's brokerage firm. There was also allegations against the builder-developer of the house by our client as well as the seller. And then there were also issues concerning the seller's own subcontract, the seller's company, because the seller's company is the company that installed the cast stone on the home. So if you didn't keep all these parties straight, that's okay. The reason why I'm telling them now is just so you can see, although it was the purchase of a home, it got complicated because there were lots of players involved. At the end, and throughout this case, it was my job to help my clients because they bought a home in which all the facts about the home were not disclosed to them. Had they known those facts, they would not have bought the home. There was evidence that we presented to the jury that showed that the defendants knew about these facts but didn't share it with our clients beforehand. The frustrations with litigation that is highlighted by this case is evident in a few numbers that I'd like to share with you. And I have to read off of it for this. 5, the number of years from the purchase of the home until the jury trial. 11, the number of months the buyers actually lived in the home. 4.5, the number of years of litigation. 4, the number of separate lawsuits in 2 separate states. 8, the number of expert witnesses and or witnesses with just technical scientific backgrounds. 2, the number of actual trials. 3, the number of defendants. 5, the number of non-parties that the defendants pointed the finger at. 14, the number of non-party contractors that were also key players or witnesses in the case. 36, the number of depositions, and there could be more. This was the ones that I could identify when I was preparing for this talk. 394, the number of plaintiff's exhibits to be used at trial. Each of the defendants had similar numbers. The number of actual documents in this case, 14,396 actual pages of documents. And again, there could be more. This is the last listing that I was able to find recently. 9,000, the number of pages of deposition transcripts. That is a lot of work, a lot of time, a lot of energy for an older couple to have to deal with, and what they explained to me as their twilight years, because someone didn't tell them information about the home they were buying. And this was a wealthy couple that could afford attorneys, that could afford to get the experts. And it still took this amount of time, energy, stress, frustrations, money, and at the end of the day, at the second jury trial of this, to get a mediocre result. As part of my advocacy for collaborative law process, I came up with 10 reasons to use collaborative law. 1, the courts are busy. Just from January through April of 2013, there were over 73,000 civil lawsuits filed in federal courts, over 5,000 filed in the state of Florida. That's really just for 3 months, because that was as of April 6, 2013. In all of 2012, there were over 350,000 federal civil lawsuits, and in Florida, over 24,000. These are just civil lawsuits. It's not administrative charges, like if you're in an employment context, doesn't cover EEOC charges of discrimination or anything like that, just strictly lawsuits. Courtrooms are busy at a time when funding to courts are decreasing. So that means that the time it takes for a case to go from start to finish in the courtroom may take longer and may get backlogged. So that comes with reasons 9 and 8, which are kind of similar but different depending on your background. Number 9, justice delayed is justice denied. That's more if you're on the plaintiff side, you're the injured party, the longer you have to wait to seek justice, it's a denial of your justice. Now, if you're on the other side, say you're the business suing another business, time is money, time saved is money earned. The longer you're in that line to go into the courthouse to get to a jury is time that's taken away from you to be able to focus on your business and to help your business make money. Number 7, I'm counting backwards if you haven't noticed. Number 7, confidentiality. Again, I talked about this in other portions of this video, is that everything within the collaborative process from day 1 is confidential. You're not going to have documents filed in court. You're not going to have public deposition transcripts. It's confidential from day 1. Number 6, the process allows each party to make informed decisions. With the confidentiality in place, the parties are still going to exchange and share information, and they're going to be a part of the decision-making process. There is in that process to make informed decision, instead of being adversarial with the exchange of information, with the confidentiality of it, there's going to be more focus on everyone's interest. So it's an interest-based negotiation that the process allows. Number 5, clients want resolution. They don't want the fist fighting of the lawyers. And I get this just from talking to different people in the business community, talking to my friends, talking to my family. I think people are sick of the image of our overly litigious society and want people to be responsible and also to resolve their disputes. Number 4, lawyers. As great as we are not experts in everything. In the collaborative law process, you have the collaborative facilitator, whether it's a mental health care worker, whether it's an experienced mediator, whether it is whatever the subject matter of your lawsuit is, a neutral expert in that area is going to be a vital role to the collaborative law process. You're going to have the facilitator is going to think of the road to conflict resolution. Even in commercial context or employment law settings, there's a lot of baggage that gets in that road. The facilitator is going to clear away that baggage so the parties can work toward the collaborative law process. And also, by having these non-lawyers involved, sometimes the collaborative facilitator may be able to review documents and take the lead in that, and their hourly rates being charged as opposed to the lawyers, which is usually a lower hourly rate that's shared by the parties. That's another separate reason that I included in here. And then the third reason is, and I guess I went into this, having that emotional baggage removed and having the path cleared away, which the collaborative facilitator allows. The second reason, shared resources, including experts, reduced cost. This was discussed with the other ones. And the number 1 reason, creativity and flexibility. The parties are part of the process, but they are guided and represented by their attorneys, the neutral third parties, so that a resolution can come and the parties can move forward from their disputes. And the biggest reason is to avoid the case that I just talked about. Avoid the mess, the chaos, the thousands pages of documents, expert testimony, trials, things like that, to resolve the dispute on your own with the guidance of your professionals in a timely and professional manner. In looking at the collaborative law process, and at the very beginning I referred to it as the new-old process, it is new. We're pioneers in developing collaborative law. It's been established in the family law area for quite some time. It's in the process of being expanded to other types of cases, the employment law cases, the commercial disputes, construction defect litigation, real estate cases, failure to disclose cases. It is harder for me to think of a case that would not work with the collaborative law process than it is for me to think of the type of case that will work. There's a Uniform Collaborative Law Act. It's a model act that's been enacted by at least 5 states. It is being proposed in at least 7 other states, and other states have similar versions pending. So it's out there. I personally have talked with attorneys from New York, from Texas, from Minnesota, from Arkansas and Alabama, talking about their efforts to use collaborative law in business, employment, and other matters. Discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the real loser in fees and expenses and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough. Abraham Lincoln said that. Collaborative law process, it makes sense. As a litigator, I see how it makes sense. In order for it to continue to expand into other areas of law, in order for it to become a viable resource in a way, alternative dispute resolution for others, it's going to take clients to ask their attorneys about it. So if you find the collaborative law process interesting, or if you see it as a positive way to help others, including businesses, resolve disputes, please forward information on to people that you may find it interesting or helpful. If you get involved into a dispute yourself, ask your attorneys about the collaborative law process. Ask them to be trained in it. And with the clients and the attorneys working together, maybe we all can discourage litigation and encourage peace.